Brent.
Thank you very much. Welcome, everyone. I hope everyone can hear me well. Let's see if I have control of the slides. All right, let's figure this out a little bit. All right. So, my name is Brian Perlberg. I will start here. So I'm talking to you today in the Washington, D.C. area. I sometimes like to joke that I'm from Washington, D.C., and I'm here to help. I really love what I do. I get to work on construction contracts all day, pretty much every day. And what's so good about it is that construction contracts really do help set the stage for successful construction projects. I think one of the premises that I'd like all of you to get out of today's talk, which you probably already have because you took the time from your busy schedules to attend today's webinar, is that contracts matter. What you have in the contracts and what they say, at the end of the day, if you have a problem, that's really going to determine your substantive rights. And if we can take more time, care, and write better, fairer contracts, we're going to have better results in construction. And one of the things that I feel fortunate that I am in the construction industry is that really it's one of the most important industry, if not the most important industry, for the U.S. economy and how we move forward as a nation, as it kind of sets literally the infrastructure for us to perform what all of us have to do, whether you're in the construction industry or an owner using the facilities. We need to have better results from our construction projects, and part of that equation, and an important part, are the contracts. So let me start by giving a little bit of what I hope to do today is give you a little background as to make the case that contracts matter and what the issues are that you need to think about, why we get a hiccup in the way we currently do it, the current situation, and then I'm going to go into some of the most important substantive terms that you see over and over again in contracts that we often don't do right. We often do them as a killer clause, and you are either on the owner side in potentially creating those clauses that you think are helping protect you, but in the end of the macro view, it may be hurting you. And then if you're a practitioner, you see how that philosophy and those terms, when they come to you, how you have to price them out and how it makes our projects more contentious and gets us into some of the same cost overruns, time overruns that is endemic to the construction industry, that maybe if we did things differently, that doesn't necessarily have to be the case. And I would say that it doesn't have to be the case. So let me begin by starting to set the stage a little bit. I like to start with this, is the U.S. Department of Labor Statistics tracks productivity in the United States. And all the good news here in the United States is all our industries, they separated out in manufacturing or non-farm and farm. And all of the industries in the United States since 1964 have increased dramatically, except for one industry. Any guesses as to the one industry that hasn't improved? Unfortunately, it's our industry. It's the construction industry. This chart marks it from 2003. I have other studies that are more recent. Certainly through 2012, I saw one, and we're the red line. We're actually in it, believe it or not, and in some ways it's hard to believe, we're less productive in putting construction dollars in place in real dollar term value and getting those results in a finished product, in getting a capital asset that the owner can use and have value in. And that is a big deal. That's a really big deal. All the other industries are increasing productivity, and ours is decreasing. And that is surprising because we're sort of on the verge of some technological advances that some have already hit the tipping point. But again, sometimes we're using some of the same processes and paying maybe higher labor wages, I'm not sure, but the labor productivity is going down. And I will tell you that anything that doesn't put value in place into the finished product is a sign of inefficiency, is waste. And what that means is, if you're litigating a claim, if you're spending time negotiating contracts and discussing and fighting over schedules, that's inefficient, because that's not directly putting something of value in place that the owner can use a capital asset, namely a building, a road, or bridge, or whatever the project may be. So I like to use a quote from Albert Einstein, smarter man than any one of us on the phone today, and I like to apply it to the way it works with construction projects. If Einstein were talking about construction projects, he might say the definition of insanity is doing the same things over and over again and expecting different results. A lot of times, we dust off the last contract we use and the same mindset and approach to the next project, or maybe we make it more onerous to protect whatever went wrong in the last project. But that doesn't work. You saw the last graph is that those killer clauses that get flowed down that we think are protecting our bottom line and passing that risk on to others actually hurts everybody. It's not optimizing the whole, and it's not optimizing the individual results, because, you know, people push back, and the process, construction is a collaboration. It doesn't seem like that it is when you're approaching it from a sort of a new perspective. If you're someone who's not ingrained in construction normally, it seems like it's a commodity, but it's not. It's something that requires collaboration. It's something, there's something that's going to prop up during the project that you didn't expect. There's going to be a problem that you have to deal with. That's not something that's a commodity. It's something that's a relationship-based endeavor. So what do people do when they're looking at their contracts? Well, they usually put in killer clauses in some of the most important areas. And I wish I had more studies that specified the results of what you use in your contract and the final projects. The two best studies that I've seen are the two ones that I have on the screen that do a job of saying, okay, what's in your contract and what are the results from those projects? The first one is a little more recent. It was done in about a little over 5 years ago. It's actually from Canada, and it took the 5 clauses that are most abused and some of the most important, right? And we're going to go over a lot of these today. And they said if we took those 5 clauses and we see the projects with the worst exculpatory, meaning that they pass the risk to others who can't control it, it's extraneous to their control. When we look at site conditions, when we look at no damages for delay, when we look at consequential and liquidated damages, when we look at indemnification, and when we look at essentially what I call work scope of what you're defining the project in, they had a sufficiency of the contract documents, and that includes finding design errors and insufficient design documents. Those 5 clauses, the ones that had the most exculpatory nature, meaning passing the risk on to other parties, those raised prices for projects 8 to 20%. And then the other study is from CII, the Construction Industry Institute, and this is from the late 70s, early 80s, where they didn't put a number on it, but essentially the projects with the worst contract documents, the ones with the most egregious terms, they did a couple things. They created risk contingencies. Contractors self-selected themselves out of projects, and so what happened is essentially the projects with the worst or most unfair contracts got the worst results. And this was both studies are consistent, and the results within the CII study was the worse the terms, the worse the results. Now, contracts, you know, I like to say, are a really important part of the construction industry. You can't say subcontractor without saying the word contract. You can't say general contractor without saying the word contract. There's a reason for that. I actually don't think subcontractor and general contractor are great terms to describe what the professions do, because they are professions that add value throughout the process. They're not commodities. If you get the best contractors, you're going to get better results. So, but the point is, contracts are important. And standard contracts, which is what I focus on in creating standard contracts, both on the consensus docs end of things, but also studying and comparing and commenting sometimes on other standard documents, is that they play a really important role in our industry. And what you see with both the standard documents and homegrown ones, sometimes they are quote-unquote homegrown, but they're really based on a standard document, or at least structurally, is that they tend to start out based upon, they're considered to be biased. They start out by one association or one perspective, be it the owner, be it the architect, be it the contractor, and whomever is drafting the original document makes a document often that is biased towards that perspective and unfair towards that perspective. So then what do you have? You have the next phase where, especially when you're taking, say, a standard document as perspective of one segment of the industry, be it, say, an architect, and then the owner gets it and they make modifications that exceed the length of the standard document because they don't like what the terms are. So now you have no predictability, which is the whole point of having a standard document. You want to have predictable best practice documents, and then you want to know what those are. Well, what happens is people don't feel like the original documents represents a fair balance of risk, or that their perspective is not incorporated in, so they modify it, and then what they do is they push the risk away from themselves, and they don't look at it as a way to macro control risk. They just look at it as a way, as in a crude matter, flowing that risk away from themselves. And you know, I say this all the time, is, you know what happens when you take something that goes down a hill? It just snowballs and gets worse and worse. So if the owner takes a document and creates an unfair provisions that are very biased towards them, they then give it to a general contractor, who then flows it down to a subcontractor. And those unbalanced provisions have to either be consistent, so the general contractor's not middled, or sometimes the general contractor has their own standard documents or decides that they need to protect themselves even more, and so they make it even more slanted and more risk shifting than the original. And then, therefore, somebody who is actually in the field doing the work has to put price on risk contingency, has to account for things that are unaccountable, unpredictable, unknown, have not been de-risked. And that's what creates a bad foundation to build. I just realized I'm working off, I'm not even sure which screen you're seeing, so I may not be pushing my slides at the right time, so I'll make a better effort on that. So here's what another illustration of this is, this picture that I like to use. It's the one on the boat who is the top of the contractual chain. And they say, I'm sure glad the hole isn't on my side of the boat. It's on the other end. But this is like a construction project, right? Is this the mentality of a lot of owners? This is a lot of mentality of a lot of construction practitioners. As long as the hole is on the other side of the boat, they don't need to worry about it. What's good for me has to be bad for you in order it to be good for me. That's a zero-sum gain. That doesn't work, because at the end of the day, it has to be priced. And if it's priced initially, you're paying higher bid prices. If it's in the construction process, if people are going to lose money on a project, they get more aggressive, and you're attracting those kind of folks who have to be more aggressive in getting change orders. You know, there's a horrible perception of contractors being change order artists. I don't think that's the case anymore. To success in the last 10 years, I think there's been a big shift, is that a good, successful project is a win for all. It's a win-win, not win-lose. But the contracts that we use really does seem to take, a lot of them in the field are more win-lose, right? And they say, well, I just put that in the drawer, and I only want to I do that to protect myself, and I only take it out when I need to. That doesn't work. It just doesn't. You need to be fair in your contracts and treat others. So what I work on is something called consensus docs, which has a coalition of 40 different groups that has owners, that has contractors, that has subcontractors, some design professionals, and outside surety professionals, as well as other stakeholders to the industry. The point here is you want to get out of that mentality of having one segment of the industry or one perspective in your contracts. You want to have win-wins. So some of the things I'm going to be using today is, even if you're not using a consensus document, you might want to pick and choose some of the provisions and say, well, this is an industry standard, rather than fight about it repetitively on every contract where you're dealing with a difficult provision or a provision you don't like. Go to an industry standard document that you do think is fair, and try to pick an industry standard document that represents all of the industry, not just a segment of the industry. So let me make sure that I'm on the right slide. There we go. This is not advancing for me. Bear with me. All right. Well, all right. So I am struggling here. Bear with me on advancing the slides. I'm doing it on one of my screens, but not the other. Let me move this down. There we go. Now I see how to do it. Okay, there's a slightly new interface for the webinar provider, and I am not totally used to it. There's just a couple tricks to it, and I got both screens up on, and so I just a little split screen action here. So, anywho, I think we got it here. So here's the question: what's a contract killer clause, right? How do you spot the contract killer clause that you should avoid? Well, the first rule here, and this goes to most of the folks who are on today's webinar, if you take the time to care enough about attending a webinar and getting educated on some of this stuff, this may be too basic for you, but it's a real simple one that in the activities I staff, I have a couple contract documents, councils, and committees that we worked. And one of the things that has been really helpful in talking to outside folks is this acronym to think about. Because even if you're mindful of it, it might be people in your organization who contracts are really important, but they're not thinking about this first basic step on spotting the killer clause and elevating certain issues. And that is to RTFC. If you want to spot the killer clause, RTFC. All right, then the question is, what the heck is RTFC? So this is the quick mantra, the first step. It's read the freaking contract, right? People often just want the work and they will sign with whatever. Or they're working with handshake deals and invoices, and you know, the handshake contract isn't worth the paper it's not written on. Now, and sometimes it's better to have an unwritten contract that has indicia if it's better than a killer clause laid in contract. But for the most part, you want to have a contract that is clear, well thought out, and you know who's on first and what's on second. So what you really want to do, though, is make sure when you get the contracts, hopefully it's a negotiation, but you want to read it, and you want to know what's right about it, but probably more importantly, what's wrong about it. One of the things you do is need to have a document management system in place, and at the very least, compare it to what if you're looking off a standard document, run a red line. Insist that you get the appendix that tracks all the changes. They are generated, but sometimes they're not shared with the folks who don't own the subscription, right? So at least on consensus docs, what you can do is if you're given a contract and they don't share the red lines, if you're a subscriber, you can upload and run a comparison of the two documents. And rather than just have a clean PDF that you don't know how it compares to the standard document, you want to know how it changed. I mean, some of it is just addresses and account numbers, but at the very least, you want to run a red line and get the appendix. You probably don't want to necessarily trust what's given to you on the list of changes that are on the, say, the AIA documents on the appendix, or from consensus docs. You should be able to trust what the changes are, but you might want to independently run a red line if you're dealing with someone that you don't know very well, or even if you do. You want to just basically focus in on, okay, what is the killer clause? So read the contract, and one of the ways to focus your attention on changes is just do a red line so you can find out what those changes are. There's a lot of document management systems out there. We use one that is used to be called Delta View, and now it's called DocsCore, that a lot of law firms use. That is the underlying red line comparison of the systems. But I think that would help a lot because, again, you're usually getting a clean document that doesn't show changes from the standard documents or the last document you got. And I think you need to put something in place to pinpoint those potentially problematic provisions. All right, so moving forward, let's talk about the actual clauses that you need to worry about. So here's a big one. This is about, hey, what are we agreeing to actually do on this project, scope of the work. So a lot of them have a provision that talks about contract documents, and if it's in the contract documents, it's within your work scope. And so here's a provision that you're likely to see on a project. It says the contract documents include all items necessary for the proper execution and completion and what is reasonably inferable, and notice that's in red, from the contract documents to be necessary to produce the intended results, also in red. So let's stop there. Reasonably inferable and intended results. So think about this. What's reasonably inferable? The answer is it depends. Is this a killer clause? The answer is maybe, but I would say that that's something that's pretty standard used. It's how it's interpreted that really matters. It does get you an area where the facts matter, and you're going to have a reasonable person, and you might be getting in arguments. And so as far as it being a killer clause, it's sort of in the eyes of the beholder of what's reasonably and what's inferable. But we're going to get into that, some tests. Now, what is a killer clause? Is this intended results? That makes little sense to me because I'm going to come back to this slide. What intended results turn builders into mind readers. I apologize, that should be mind readers. And what does that mean? So it's not as indicated in the contract documents. I mean, it is arguable that it would be acceptable to say intended results as indicated. But if without the as indicated, a lot of people want to just put the intended results. How are you supposed to realize, how can you cost out someone's intent if it's not written down, if it's not communicated, even verbally? You know, sometimes you should be able, if it's reasonably inferable, there's something that is indicated that it's in one document, not another, and then industry norms are that it should, you know, that connection should be connected. If there are, you know, outlets, that there needs to be wiring that connects to those outlets, those type of things. But again, you know, what I'm seeing more and more, and the calls are getting louder and louder, is there's a real problem with the adequacy of the design documents, that if you're working on a design bid build, you have to meet the contract document requirements or it's considered defective construction. But there's not, but remember this, is design documents are never intended to be perfect. So there's a gray area. Maybe they're 90% accurate, maybe they're 95% accurate. I mean, they should be enough to be bid and build, but there's going to be a level of errors in those. Sometimes a contractor can pick those out and should be able to price it. Other times they can't. But if you're going off a standard of intended, then everything is up for grabs. Just remember that, you know, there is some review of documents that should be expected, but you're not paying a builder to be an inspector. One of the things that you can do is include an order of precedence clause, because sometimes the documents conflict. It says one thing on one document, it says something different on the other. Well, which document should govern? So we're going to go into that a little bit. Now let me just go back to this slide here. Beware of language negating the Spearman Doctrine. What is the Spearman Doctrine? It means, especially in design bid build, if you're given a design, the owner may not get perfection from the architect or engineer because there's a professional standard there, but when it's put out to bid, there's an implied warranty of the fitness of the design, and that's called the Spearin Doctrine, and it's based upon a Supreme Court case with that had two ships Spearin, or I'm sorry, it was reference to two ships. Actually, not two ships. Sorry, that's another case. But the Spearin Doctrine about the adequacy of the design documents on a ship dock, and that was flooded, and that was not able to make the project because of the site conditions, essentially. So the risk of this little gap between professional standard of the design documents and then them actually to be buildable, that risk has historically been on the owner and not the contractor builder because of the sort of this gap that's created in the design bid build. And that's somewhat unfortunate for the owner because they're not getting perfection, and they shouldn't be able to expect to get perfection, but they have to have contingencies for when the builder has to build to the design documents, and those design documents have errors, and there's something that is preventing the project to go forward as it's intended. So that risk is on the owner, but more and more you see these killer clauses that shift that risk of the design documents which the contractor could be helpful on if they're involved early, but often just have to price out what is on a bid job. That risk is often being shifted to the builder, even if they haven't had an opportunity to even review the documents adequately to price those out and report discrepancies. So there's a lot of language in the documents that try to negate the Spearin Doctrine. And so more and more builders are going to have they have to sort of price that out to make sure that they're not getting stuck in an unreasonable owner. Now let's go back to the reasonably inferable. What's reasonable? Again, I said it sort of depends. If it's omitted from the plans and specs, that is a good example of something that is not reasonably inferable, and it results in a material additional cost. If it's omitted from only one document, then it's maybe reasonable if it was omitted on one document but is indicated on another. If it requires additional design work for you to be able to say, well, hey, you should have been able to look at these design documents and said that you had to do, this was in the scope, but I need to amend the design documents and get them restamped. That probably is not reasonably inferable. If any submittal is required and such submittals were not specified in the schedule of submittals, that is, and these are in sort of the order of importance or how convincing it is. This would be tougher, but I also think that if you have additional submittals, that's a good example of something that probably wasn't reasonably inferable. If the work requires material changes to the sequencing of the schedule, that may be an indication that it's not reasonably inferable, was not intended in the original project scope. And then again, the order of precedence, if the documents conflict, you want to have what you have if you don't address it, which are in the AIA standard documents and other standard documents. They basically do not have an order of precedence in the standard language. And so what that often does is someone will say is, well, whatever's most expensive or whatever I deem later. Well, how do you price something that the documents conflict, but you're supposed to anticipate that there's going to be all conflicts and you're supposed to price those out? There's variety on that. That is nearly impossible to anticipate. In fact, that's really the standard, is that the documents conflict. You weren't supposed to be able to anticipate those because that was information not given to you at the time that you negotiated the price or put in your bid. What you want to have is an order of precedence rather than going to litigation of whether something was reasonably inferable or the documents conflict and this document controls over another. You want to have a system in place that tells you this document takes precedent over another rather than fight over it. And so consensus docs in the standard language has a system which says the more recently created contract documents, such as a change order, in general, will have a higher precedential value than ones that were created earlier in the project, where we had less information and less time. There's certain documents like plans and specs, though, that govern over some other documents because that they are more care in creating certain documents within the process. But in general, the more recently created documents govern. And by doing this, you can then say, well, okay, this document, we don't need to go to court to say that this document controls over the other. We have a system in place. Because there's a lot of money that is spent on arguing over which documents. And again, the golden rule of whoever has the most gold makes the rules, that's not something you can price out, and that sets an unbalanced structure and foundation to build. Now, the other thing to think about is how do you structure your agreements? When you're looking at contract documents, a killer clause might be is that you have sometimes references to general conditions documents on a project, which is something that terms and conditions that you see if you're like have a master agreement, there are provisions like indemnification and notice requirements, all those type of things where are in the sort of standard general conditions, and that the agreement is more project specific, and that is the contract, so to speak, and then it references those general conditions. Well, sometimes a killer clause is that those general conditions that are referenced may be heavily modified from a standard document or are just referenced but not provided, and there's not a meeting of the minds as to what are in those general conditions. That potentially is a killer clause. One of the things that consensus docs does, which is an approach you might want to take, is incorporating the agreement in general and in general conditions into one document. Try to make them use plain English so that they're better for contract administration and clarity and understanding. But the main thing here is the hiding the Easter egg general conditions modifications, which may or may not be, depending on your state, enforceable if they're not provided. That is something that can be something that sparks fire down the road for litigation. All right, moving to another important differing provision that's a killer clause is differing site conditions. And depending on your perspective, even that Spearin doctrine was essentially created by a case that was dealing with differing site conditions where the parties thought, oh, hey, the soils would be, this in the Spearin case didn't deal with soil conditions, it dealt with really water flow on a dry dock. But the owner, the general contractor, and all the participants think, okay, these are the typical site conditions in this area, and I'm going to be able to use this type of equipment and use these type of procedures to successfully make the project. A differing site condition pops up when that normal site, and maybe you did a couple borings of the field, turns out that there is a lot more rock, or that there's a lot more water, or there's something else that is preventing the normal completion of the work. This is something, when it pops up as a differing site condition, can be quite expensive and really can drastically increase prices. Historically, this is something that the owner has the site, and they usually take on that risk. But a killer clause is shifting that risk usually. And again, this is something that it doesn't happen all of them, but when it does happen, it can be quite expensive. How do you spot the killer clause dealing with differing site conditions? Well, typical on projects is an obligation to study and compare the contract documents, but coupled with more and more language saying the failure to discover a site condition, that you would start making affirmative warranties that the current conditions are sufficient for you to complete the work. This again is making the builder an inspector. Ways that this is done to pass the risk successfully, and you can transfer this risk contractually, is you start having obligations to take field measurements and verify field conditions. Often that's done before the price is set. There are geotechnical reports that, depending on whether they can be relied upon or not, or whether it's for informational only, whether who's doing the geotech reports matters a lot. But maybe it would make more sense. Let me take an opportunity to show you a good example of a differing site condition that's really unfair and hard to price. So this says, contractor represents that it has inspected the project site, reasonable, and has satisfied itself of its the condition thereof, and that the GMP is sufficient to cover all the work, including all foreseen, that's fair, and unforeseen, in red, risks, hazards, and difficulties in connection therewith, including without limitation any concealed or subsurface conditions at variance with the conditions indicated by the contract documents or other documents furnished contractor for its information. The services, information surveys, and reports to be furnished by the other consultants employed by owner shall be furnished with a reasonable promptness at owner's expense, and contractor shall verify the accuracy and completeness thereof. So again, the owner's in the best position of knowing of their property, but at this case, even unforeseen risks are being transferred. There's no limitation. It's not just site conditions that are in plain sight, but they're ones that are concealed in subsurface. And it's conditions that are different than those documents, like a geotech report, that were given to the contractor, which is only for their quote-unquote information, and they can't be relied upon, but certainly is an indication of what they would anticipate they would see in the field. So this certainly is something that I think you'd be hard-pressed to get a reputable general contractor to fully agree to, and if they do, they're really putting on some real risks there. So how do you get out of this kind of situation where you're dealing with the contract killer clauses for differing site conditions? This is one where the federal government and the federal acquisition regulations is pretty good. The standard documents all provide for relief in their standard language when the differing site conditions exist. If you get some language, and this is true of everything we talk about today, if you get language, don't be afraid to ask for fair language. It's not always a take it or leave it matter, even on a hard bid situation. With differing site conditions, the facts in the field, again, matter. What were the conditions encountered? What was the documentation? What notices did you provide? What is normally anticipated? What were those geotech reports? Where were the boring samples taken? All of that matters in making a case for a change order or not having a change orders. Remember, the more inspections that you're doing before setting the price and being obligated to do is potentially increasing your liability. And just remember, from a builder's perspective, and this is something that we'll talk a little bit more with design delegation, is pre-con services, pre-construction services, certainly for CM at risk, that are provided. The more the builder is involved in those pre-construction services and getting compensated for them, the more liability exposure they're getting, more opportunity to solve problems, so there's really some good benefits there, but they shouldn't be free services because you're providing valuable services and you're increasing your liability exposure. All right, let's move on to no damages for delay, another key killer clause. And this provision is generally referred to no damages for delay, and this is when one party is causing a delay and they allow you to get extra time but no money compensation for the delays they created. Another version of this is where you get time and you only get money if you give very, very quick notice with documentation of the increased price that you're incurring as a result of the delay. And so that's something where, you might have to give notice even if you haven't even determined, even if you didn't even realize there was a delay, and it wouldn't be reasonable for you to know that a delay was caused, but you've already missed your opportunity because you missed your notice provision. And then another version of a no damages for delay, which is not quite as bad, is you can get time and then you can get money, but that money is limited to your direct cost and increased general conditions or extended general conditions. That might be something where you're starting to get pretty reasonable there, but that it's certainly not fully compensating for you for the impacts of the delay. So what do you do to avoid contract killer clause for no damages for delay? One is, we haven't talked about this yet, is that if there is a conflict between what's in your contract and state law, what do you think governs? State law or your contract? The answer is state law will always govern over what's in your contract. Now, the little footnote there is sometimes there'll be state law that says you can't have a no damages for delay provision, but there might be some language in there that will allow certain things if it's explicitly in your contract. And that applies to other issues too, some that we'll be able to talk about today. But in general, state law trumps your contract. So if it's in your contract one way as a killer clause and state law doesn't allow for that in the private sector, if you're dealing with a private sector contract, then it's unenforceable. Now, with regards to notice requirements, this is something state-specific as it's how interpreted. Sometimes, again, I mentioned before about how you have requirements to say, I encountered a delay situation. Again, some state laws will have more favorable interpretation and not bar your claims, saying, hey, the owner can only say that they're not going to pay for your no damages for delay if there was actual prejudice for you not giving them proper notice, that it didn't really hurt them that you didn't give the notice, and therefore the claim can move forward. The other way that many states have will construe the facts in a situation is they'll say, well, they didn't give notice the way they were supposed to. They didn't do it in writing. They didn't send it. They did it verbally, or there was action that was taken. So that would be if the owner knew about the claim but didn't have the formal notice from the contractor, or it wasn't delivered properly. Some states will say, well, that was actual or constructive notice, and will allow the claim to move forward. Another thing to think about is the strategy in negotiating terms, and this goes to the a tiered approach, is saying, look, I have to give quick notice saying that I am delayed, but I'm not going to have all my ducks in line, and this is more the killer clause, of all the documents and an exact setting of the equation for the cost of those delays. What's fairer is to say, okay, I have to give notice there's delay, and then within a certain reasonable amount of time, maybe that's within 30 days, the proper documentation, and that you get those 30 days to demonstrate how much time was lost and how much expense was incurred. And just remember this, on these kind of provisions, this is one where if it's at the prime level, that especially getting notice from a subcontractor or general, these provisions need to be flowed down to your subcontracts consistently. And you need at least some time as a general contractor to evaluate the claim and passing it through. Sometimes that pass-through is maybe automatic with a reservation of rights to evaluate it, but again, you want to at least have some time so you get notice from the subcontractor and then passing that claim through. All right, let's move on to change orders. I love talking about change orders, and unfortunately they're sometimes contract killer clauses the way they're written. What's neat about construction change orders is that, from my perspective, they're in some ways unique to the construction industry because construction is complicated. Because on every project there's going to be some change from the beginning to the end where the parties thought they had one understanding when they entered a contract. They know that that's going to change. The owner's going to change their mind on some feature they want. There's some field conditions that have changed, or some of the design documents need to be changed because they don't quite meet constructability, or for whatever reason that from start to finish. I haven't talked to anybody yet who's been on something where there hasn't been any kind of change or any kind of something that had to be clarified or corrected before the project. So we actually write that into our contracts in construction that's saying, yeah, we're going to have a change. It's not going to negate our contract. We're going to have a way to handle these changes, but usually if there's a change, then sometimes people will say, well, it's not a meeting of the minds from the original intent. But again, in construction, that's not the case. In fact, we have terms for that. In the AIA standard language, it's constructive change directive when it's ordered. In consensus docs language, it's called an interim change. An interim directive. That should be updated. We changed the language recently. And this is a way where normally a change order is something that is agreed to mutually and the amount of compensation involved. But when it's ordered by an owner, it is then an order, and that is directed. Now, when it becomes a killer clause, it depends on how you're compensated when you're ordered to do the work. If there is a dispute as to what's in scope and what's out of scope, and so the owner says, oh, I've already paid for this, you were already being compensated to do this work, and the builder is saying, no, this is a change, this isn't something that we have agreed to, I need compensation for this. The killer clause is, depending on how this works, is you might be turning the builder into a banker, because under a CCD or an interim directive, the owner is not necessarily paying the full amount for the labor and materials. So one way to neutralize this is, at least in this case, is look to the standard language. What consensus docs does says, okay, one party, we don't want to give it to all one or all the other. Most times it is 100% where the payment is coming from the builder. Consensus docs takes a sort of a 50-50 approach, where both the owner and general contractor or subcontractor, as it flows down to the subcontract, gets payment. They get payment for undisputed work. They get half payment for disputed work, and that is based upon committed funds. We used to have it so it was an estimate, but now it is based upon sort of the invoices as they're received. Now, there could be a true-up if the owner pays more than they are liable, what was ultimately determined and agreed to. If it's if they're paid more than 50%, I'm sorry, if they paid 50% and they shouldn't have had, they don't lose their substantive rights. So that's when you would true up the contract. But the danger is when you have one party paying 100% of the costs, that's excessive. And that can be even used as leverage to, again, to have this sort of zero-sum mentality where one party has all the control over the other. The other thing you might want to put in your contracts that could be helpful, and this is sometimes based on case law as far as how this is interpreted, is having a cardinal change. So I said before in construction that you don't negate the contract just because there's material changes, because we kind of anticipate that. But there's a whole slew of cases where little drips and drabs or maybe big changes add up to, hey, 5% changes is not necessarily a 25% change. It becomes cumulative, and there's cumulative impacts. But what you might want to have in your contract is something say, well, look, if we're going to have changes that represent X percentage, say 25%, and that's not a magic number, but if it's going to be so many changes, the terms that we agreed to in the overhead and the field office overhead that I committed to this, it's so different, the work is so complicated with these changes that we didn't foresee, that everything is up for grabs, and that the contract, this is a cardinal change. That is language that might be helpful to counteract some abuses of change orders. The other thing that I would recommend is spelling out what the cost of the work is, even in a lump sum contract. The most prevalent cost funding of projects is still lump sum, fixed firm price for design, bid, build in construction. In the consensus docs, there's a really long section in the lump sum contract for cost of the work. Why is that? Because when you do changes, the changes are often a point of contention, right? Changes just generally are contentious, especially for public owners where there's really political issues with having, depending on their budget, a cost overruns. So if you in your contract can upfront say, hey, this is how we calculate a cost of the work, because this is a lot of times the sort of ambiguities that then lead to disputes. The more clarity you can put in your contract up front, what's a fair way of determining that, that's fair for both sides, you should do it. And so that's something where, again, I haven't said this yet, you can plug and play some of this stuff. I did kind of make some allusion to it. If you want to you have your standard document, you don't want to move to a new document, you might want to say, all right, well, you know what, I see this point, order changes don't make sense, that's hard to price. let me put a cost of the work. You might want to plug and play a section of one of the standard documents into your agreements and use that going forward. And then one thing I'd also recommend is when you do have an order change, when you do agree to it, you have to have you should memorialize that in your paperwork, and that's something at least in consensus docs where you're required to settle up and with a written indicia that your ongoing change orders as they're agreed to are memorialized. Now let's move on to indemnification. I think indemnification is one of those everybody, we can all agree within the first, top 10 killer clauses. Indemnification is going to make anybody's list. It's one of those things where your eyes go to that provision in your contract and make sure that you're protected. This is a serious transfer risk issue, and it's something that has been legislated a lot because while I don't think that legislating private contracts is necessarily the way to go, indemnification is one of those, and there's also insurance forms that are associated with this that have been heavily legislated and heavily commented upon, and lots of insurance forms that govern over this. So for indemnification, a killer clause would be something where what has been generally called broad form indemnity, where someone might be fully at fault for something and they make the other party pay for their negligence, right? That's broad form. Now, what concurrent negligence would be is something short of broad form, anywhere that is, I don't know if it's 0.1 or 1%, where if one party is 99% at fault and the other party is only 1% at fault, that probably is enough still under state law to pass that risk for indemnification. These killer clauses indemnification often include a duty to defend. They often are very broad in identifying what kinds of claims that are indemnified. So you're working on a construction project, sometimes they throw in all sorts of types of claims that are not related to third-party injury or property damages. They could be defamation or other things that's even hard to sometimes imagine. And then another killer clause, and this is maybe the smallest point to make on indemnification to look for, is that the indemnified party needs to consent on settlement, even though the other party is paying for that settlement. So what are strategies out of killer clauses? One is there's just this general principle that I think is compelling to argue on the other side, is saying, hey, I want to be responsible for my negligence, but I don't want to be responsible for the negligence of others. I want to be responsible for bad actions that I took. Maybe they're negligence, maybe they're intentional, which is unusual, but does happen from time to time with a rogue employee or rogue subcontractor. But I don't want to be responsible for negligence or intentional acts of others. So try to limit it to your acts. Try to limit only to the in general, if you can't insure it, you shouldn't indemnify it. If it's intentional, that's just a business risk. Limit to third-party bodily injury and property damage rather than any kind of claim under the sun. Again, that goes to the broad, undefined, really, types of claims that are covered by indemnification. In general, you want to have a right to defend, but having a duty to defend sometimes the defense can be more expensive than the claim. And so you might want to shape your defense, but having a blanket duty to defend can sometimes, I think some people could argue both sides of that one, but in general, it's better to have the right to defend, but not the duty to defend. But again, remember, it matters whether you're limiting to your percentage of negligence. And then one thing to keep in mind, going back to state law, is in some states there has to be some specific consideration for getting the indemnification, and if you don't, it's not enforceable, such as in Florida. And there's the site right there. Let's move on to another important provision, and that would be retention. Right? Anything dealing with payment is something that people definitely are looking to in their contracts. It's very typical for retainage to be included in construction contracts, of course, but at a certain point, could become a killer if the percentage is too high. Remember, the purpose of retention is so that payment for work is commensurate with the work that's put in place. But retention shouldn't be a project funding source. It shouldn't be looked at from the party as saying, well, I've got money to fund this because I'm only paying 90% on the dollar, right? It's not leverage, undue leverage over the downstream parties that are having retainage. That sometimes the people miss that point, right? Because the purpose of retainage is, hey, you know, the owner there's a payment schedule, there's application for payments. They've paid 60% of the project, but only 40% of it has been put in place. And then all of a sudden there's a problem, and they've paid more than what they've got, and then there's a defaulted contractor, and what are they going to do? So that's the reason why you have retention, not some of these other things. So what some folks do, I think it's a good one. It's actually included in consensus stocks. Once the work is 50% complete, no further retainage is withheld. That's a nice way. So you're probably going to have a higher percentage in the first half to protect yourself. But then you have some security with the work put in place. It's not like the owner doesn't have any security in work that they can use if something goes wrong. And anyway, that is a progressive but fair approach to take regarding retention. And just remember, usually retention is released at substantial completion, except for punch list items. And just remember that you have clear language that is the case. As it gets downflow to the subcontracts, you have to make sure that it's probably going to be substantial completion for the overall project rather than the subcontract work. And in some ways, that's not fair to the early finishing subcontractors who could finish their work and wait 2 years before getting final payment on a project or getting their retention back. Think about ways of speeding up payments, and that's a great way of getting the best contractors at their best prices, right? And that's a really big point here from an owner's perspective is, you know, I'm always seeing that collaboration is the way to go, building those teams. You want the contractors to give you their A team, or maybe their B team, but hopefully their A team. Well, when you start having fairer contracts and have quicker payment options as part of that, you're more likely to get their A team. You're going to get the C team, or hopefully you shouldn't be hiring them. And these are some of the ways by having those fair terms that you're going to do that. Another example of a killer clause dealing with payment is for ways where payment is withheld, right? Not retention, but no payment. Some killer clause contracts say, well, if I anticipate you having a breach, I can stop paying you. That's really a nice ending of the honeymoon, right? If you say you haven't gone overboard your GMP, but I project you to, so I'm going to stop paying you, that's really squeezing the builder. That's an example of a killer clause. And again, same type of thing of projected to not hit substantial completion date, that you're behind schedule. So instead of accelerating with some extra money, you're cutting off money. Those are things that are counterintuitive, but are usually put in some kind of protective killer clause contracts. That's probably one of the reasons why we have projects that don't get the best results with those more egregious contracts. Another important topic is on contracts that you're going to look at is consequential damages and how they relate and interplay with liquidated damages. You know, consequential damages is one of those things where it's not a direct cost, it's a consequence of that. And what is a direct damage? It's sort of like the famous Supreme Court case where that's hard to determine sometimes and define it. You can provide some commentary, and the better you can define it helps. But you know, where that line is drawn of a direct cost and a consequential cost sometimes can be difficult. Here are some things that are examples of consequential damages: is lost income and profits from projects, or the failure of the project to be opened on time, owner's loss of use. Well, owner's loss of use. The biggest case is a gambling casino that was supposed to open and it didn't, and as a consequence of that, they lost a lot of profit, and then ultimately the builder had to pay for the anticipated lost profits from gambling as a result of a consequence of not meeting the schedule. So when you think about that for a second, when you're talking about gambling profits, it's not going to take long to get a contractor out of business when they have to be responsible for someone's gambling losses. Other consequential damages are rental expenses. Say if you're renting facilities because a project's not met on time and that there's rental costs incurred, additional finance charges, extra time, extra interest. Someone goes bankrupt, your reputation, you're known as someone who doesn't open up on time, or people put your reputation as a builder on the line because there was some back and forth on an aspersions cast. Those are examples of indirect consequential damages. Now, liquidated damages are examples where you say, okay, well, this often is, we can't agree on what the damage, especially the day that we sign. So we're just going to set a reasonable calculation that there's an articulated reason for doing this. It's not a penalty. Liquidated damages, it's going to cost me, say, $25,000 a day to not have that stadium open on time, right? Or the casino to open on time, I anticipate. So we may not be able to agree on what my gambling losses are, but we can agree that I'm going to specify that that's $25,000 a day. At least you then know exactly, as the builder on the builder side, what exactly you're facing. If it's a penalty, if you say it's $2 million a day and there's no way you project to make $2 million, well, guess what? You can put that in your contract, but it's not going to be enforceable. So liquidated damages are often used, and they need to be calculable. They need to be reasonable. They can't be a penalty to be enforceable. But you're often going to see that. So a killer liquidated damage is probably not enforceable. Consequential damages are often waived in construction projects. All the standard documents do that. Consensus Docs has a sort of a somewhat of a waiver of it. But everybody knows, because of that Perini case with the gambling casino, that since the late 90s, people have handled that in their contracts. But you still certainly see it a lot, and it helps when it's articulated as a liquidated damages, or in consensus docs, the consequential damages, you kind of spell those out. So you say, I anticipate this consequence, and this is how I value it. That at least provides some certainty as to what the risk that you're guarding against. A lot of the killer clauses do not specify that the consequential, they'll actually say the consequential damages are not waived. It's better to specify the pricing and methodology that are used. Liquidated damages are a great way to incentivize somebody. From an owner's perspective, I've heard a great owner talk about it this way: is, I want to incentivize them to accelerate if they're behind schedule, that they feel my pain, but that they don't. If they're going out of business because I'm assessing liquidated damage, doesn't help anybody. So you want to provide the right incentives, not the wrong one. And here's a strategy out of contract killer clauses regarding liquidated damages. If someone says, well, it's going to be $2 million if you're late, maybe you should start flipping this around, the conversation, to say, if it's $2 million a day if I'm late, do I get $2 million a day if I'm early? Because you can operate. So most contracts talk about everything you shouldn't do. It's better to have some language in there of what you should do, and maybe even some incentives and risk sharing to get everybody rowing in this right direction. Now, one thing I would say is, you're talking about incentives. I'm familiar with consensus docs. In the standard language, there is no incentive early completion language, for instance, but we have something called a guidebook. If it's appropriate for that project, there's a guidebook that's free to download, and basically you plug and play that you can get an incentive for certain. It's kind of the reverse of a liquidated damage. But from a negotiation strategy, here's just some model language that you can use. That's a good counter to consequential damages or liquidated damages that aren't fair is talk about, well, is there some incentive if I go above and beyond, and how does that compare to what you're penalizing me for? Usually there's some relationship between the penalty and the reward, right? Okay, moving on to termination, another killer clause. In my mind, and sometimes when you're doing termination, it's what I call going nuclear on a project. One that is not going nuclear, as far as when you're doing it for cause, it's going nuclear, because that's really casting aspersions on and has consequences for the contractors and subcontractors on the project. And people tend not to want to do that, and they fight really hard on that one. The other one is termination for convenience. Now, one way on termination clause, if it's for convenience, there's usually some compensation. Obviously, there's profit and overhead on work performed. But the question is, what about the work that's not performed? Some contracts, if you're not paying for profit and overhead on work not performed, either through a premium that is specified, kind of like liquidated damages. You say, if I'm going to terminate you, you were anticipated to get this, so here it is. Or you could say lost profit and overhead. And remember, termination for convenience is when it's not the fault of the terminated party. So, you know, the owner's financing goes dry, and so the project's terminated. That's not anybody's fault. And so there should be some compensation for the builder who lost opportunity and has to demobilize and such. So a killer clause, though, would be one where, hey, it's almost like a contract of illusion where you say, hey, my funding ran out. I'm sorry, you're terminated. You don't get your profit for the work not performed. You don't get any demobilization cost, and all the litigation, legal fees that you might have dealing with subcontractors who you're also going to have to terminate, or other types of activities as a result of this unfortunate termination that, again, wasn't your fault. That's just on you. So that would be an example of the contract's almost illusory because you can cancel it at any time. And then a killer clause would also go on to say is, but you're also going to give me a liability of the work that you've performed, even though you're not there to secure it or complete it. So those are things you should be mindful of not agreeing to. So ways to negotiate out of a killer clause for termination for convenience. One is, if it's for cause, you should have an opportunity to cure before you're terminated, because you should have an opportunity to fix the problem. If it's termination for convenience, you have to have a premium or lost profits and overhead to prevent against arbitrary termination. And this is something where there's been some changes in the standard documents, and it's really important, if there is a premium, that you have something that reflects your costs. It's better to have certain things carved out of that, like your demob cost, attorney's fees that are directly attributable, things that are covered by insurance, for instance. Those are things that help de-risk the project, not having a blanket premium, which isn't great. But whatever you do, you need consistent language from your prime agreement and your subcontract agreement. And in the standard documents, on one of them, on the AIA, that language, and really there's some issues with both of the standard documents, is you need to make sure that you flow this down on the termination convenient, try to make it consistent. And again, not giving warranties on work that you're no longer controlling or have access to is something you should negotiate. Now I want to move on to dispute resolution clauses. When I talk before mostly legal audiences and talk with fellow lawyers, they love talking about dispute resolution, arbitration, litigation, and what are we doing with mediation. Always comes up, like more than payment, right? When you're talking to contractors and subcontractors, always want to talk about payment provisions. Lawyers always want to talk about dispute resolution provisions. As far as a killer clause, is some examples of dispute resolution clauses that are killer are ones where one party, often the upstream party, gets the right to decide unilaterally whether it's arbitration or litigation after the dispute arises. They sometimes include a very inconvenient venue choice. So let's say the project's in California and they want to have the venue in New York. That's incredibly inconvenient, especially for the project participants. there might be a reason for that, but like their headquarters are there, but that really discourages claims. The other thing is watch out for one-way attorney's fees, or the worst is, hey, you have to pay my attorney's fees even if you win. I've seen that. But a lot that you see is where if I win, you pay my attorney's fees. If you win, I don't. Nobody pays. Those would be examples of, hey, it's not good. It's one way. It's not good. If, like I say, if it's good for the goose, it's good for the gander. One of the things you should do or think about plugging and playing in your documents is having not contractual communication silos. A lot of contracts are very siloed in their approach when sharing information, and that doesn't work. What does work is the parties talking in real time. One of the things that has been really effective, and one of the reasons I think where you actually haven't seen any reported cases dealing with consensus stock standard documents, and I'm not saying that there's been fortunately there's not been lots of disputes dealing with them, but there's not any reported cases. One is that the parties have to talk to one another, and I suggest you look at this tiered approach where there's communications at the project level and the senior project management level in real time before the claims get intractable. That really pays dividends, and that's different than mediation. It's it's kind of sort of like a dispute review board or a project neutral, which are also written in as options and something you should think about on your projects, because litigation is something where neither party wins. And I think more and more people realize that, but there's still a lot of litigation and claims in construction. So let me move on to something that probably when I first started doing this presentation a while ago was not included, but certainly is worth including today, and that's design delegation. That's probably something that has moved from a back burner issue to a front burner issue. And you see this, we're not talking about design build projects, but you're seeing, again, one is we've seen a deterioration in the buildability and being able to bid on design documents, the quality of design documents. I'm hearing from time to time on certain projects is more of the chorus of complaints are louder. Let's just say that. And more the requirement to perform the design or in elements of the projects are being delegated to the builders, right? And I'm not just talking about fire safety systems and sprinkler systems, which has been done that way a long time. I'm talking more about really big elements of the project that would typically be done from the responsible architect of record or engineer of record. So sometimes it's hard to spot design delegation. In certain states, it could be illegal to delegate design unless there's specific design criteria that is associated with that. So if there isn't specific design criteria that you're performing the design to, especially in New York, you could be violated. You might be having a misdemeanor charge. So you want to make sure that you have design criteria that you're doing the design delegated design to. And again, I'm not talking about means and methods design delegation. The larger the element of the design, the more problematic the delegated design is. The more it's hard to find what you're being delegated. A lot of times it's being hidden in plans and specifications as a performance spec or a hybrid prescriptive and performance spec. And then so to meet that requirement, you're going to have to perform design and you're going to need to get stamping for that, but it doesn't explicitly say it. The best would be to have it in an exhibit before at contract signing. But again, more and more, some of those elements are not fully complete at the time of contract signing, even if it's a design bid build case or project, I should say. Another killer clause, and this does apply specifically design build, but any of them, is signing up for fiduciary responsibility by a design builder would be a killer clause. And of course you're getting the design delegated in design build, but being a fiduciary from the design builder to the owner is not something that is typical, it's not insurable, and it has a whole host of problems. And it's surprising that that actually is included in the standard AIA's design build language. Another thing to think about with design delegation that's a killer clause is that the architect of record or the engineer of record should have some design coordination for the specific elements of design that is delegated. More and more, it's usually not just the general contractor doing the delegated design. It's usually elements that are being delegated to various subcontractors, and how that all flows up and gets coordinated, somebody needs to be in charge. If everybody's in charge, nobody's in charge. A lot of times it's written where it's anticipated the delegated design to the contractor it then flows up to the owner and the architect as being perfect, which doesn't make sense to me because, as we mentioned before, you can't expect perfection in design, but sometimes it's written to contracts when it's flowing up on the delegated design that suddenly it is being warranted. So, again, try to put it in an exhibit if you can. When it's being approved up the chain, a lot of times the owner and design professional get the delegated design and they don't actually have to approve it, and they have what I call weasel words about acceptance of it and the warranty that's provided by the provider of the delegated design. You want to have clear approval language in the delegated design and as those elements, and don't warrant perfect design. Require that there be some design coordination. Last but not least on our killer clauses is pay if paid versus pay when paid. They sound real similar, but this is where who has the risk of non-payment. So pay if paid is basically putting the risk of non-payment if the owner doesn't pay for the project. Then the subcontractor is agreeing to not be paid and is taking on that risk. This is a real controversial issue, heavily negotiated, legislated in the states, and you have to be careful how it's legislated in the states. This is definitely one where if it's written, it might be written where it's strictly construed, whereas they don't like the language, but if you have the magic words, some states that people don't think pay if paid is enforceable actually is. You just need to have the exact right language. Regardless to say, you know, a lot of people feel strongly that it isn't a killer clause, right? Because how can I pay you if I haven't gotten paid? The pay when language is, look, I don't have to pay you immediately because I haven't gotten paid, but I have to pay you at some point, right? And that varies from state to state of what's a reasonable amount of time for payment. But at some point, if the owner isn't going to pay, that obligation under pay when paid is the subcontractor will get paid. So just remember, if your state law says it's unenforceable in the private sector, then pay if paid as a clause it will then not be paid. None of the standard documents have pay if paid in the language. Just know that it's not that hard to change a pay when paid language to a pay if paid. So just let me go back to the opening here of, let's put this in perspective. When you're thinking about your contracts, I love this quote from Construction Industry Institute. It's ironic that the one industry in the country which more than all others depends upon coordination, cooperation, and teamwork among multiple participants should be the country's most adversarial industry. Again, how we handle our contracts has a lot to do with that. A big example would be the state of Iowa Department of Administrative Services made a huge change in the way that they did contracts. They went from a highly modified AIA document that was paper intensive to making a switch to consensus docs and using building information modeling and using construction management assistance agency. And they doubled the amount of projects they were committed under contract. They went up 50% on the amount of projects they completed in a year. And to date, they went from having a formal claim on every project, because they were considered a bad owner and an aggressive adversarial owner, and their process led to this, and their contracts led to this. They made these changes, and they haven't had a formal claim to date. They went from being an owner of last resort to an owner of choice, and the results speak for themselves, and they're quite impressive. So with that, I'd love to take some